Welcome to Rapid Fire Wednesdays, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner in our San Diego office, and I'm joined as always by Miki Matrician, co-managing partner of our Boston office. How are you doing this week, Miki?
I'm doing well. How are you, Kim?
I'm doing good. I'm excited that I'll be in Boston soon, so back on the East Coast. We'll
Yay.
get together, so it's exciting. We're going to talk this week about various updates from the government, including from the State Department and some TPS updates. So, Mickey, there were a couple of updates related to the State Department on interview locations and third country processing. Can you give us an update on the immigrant processing and what's going on?
Yes. So in the past, applicants for a green card through an interview at the consulate or embassy abroad could request the location that was not their country of residence or nationality if they had some ties to that location. And applicants could make such a request at the National Visa Center, which is an agency within the Department of State that handles the paperwork submitted for immigrant visas, also known as green cards. So at the end of August, the State Department announced that as of November 1st, the National Visa Center will schedule immigrant visa interviews in only the applicant's country of residence or, if they requested, their country of nationality. So, for countries where routine visa operations are suspended, the State Department has designated an alternative location for the interview. If the applicant is a national of another country that has operations, they can also process at that country as well. So, the State Department has said that appointments that were already scheduled would generally still be held as scheduled.
Yeah, that's right. So the State Department is also stopping third country processing for non immigrant visa interviews as well. So this new policy for non immigrant visa applications is effective immediately. And the State Department is requiring non immigrant visa applicants to schedule visa interviews at their country of nationality or residence. So, here again, too, if the US government has stopped routine operations in a particular country, they have designated an alternative post where the individuals can apply for their non immigrant visas. And as with the immigrant visas that you were just discussing, Nikki, the State Department is saying that existing visa appointments will generally not be canceled. However, we have heard of a couple of situations in which the consular post was unsure if they could process the non immigrant visa application and are waiting for additional guidance from the State Department.
Yeah, and these new policies, combined with the elimination of interview waivers or Dropbox programs for renewal applications, is expected to create a huge backlog for certain consular posts, especially where they have high volume, like India, China, and others. And so, for global mobility and HR professionals, it's all the more important now to be aware that the foreign national employees who leave the US without advanced planning might find themselves stuck abroad waiting for an interview appointment and a little while for completion of their visa processing. So it's hard to believe that less than a year ago, we were still hopeful that the State Department could make permanent its pilot program on domestic renewals of expired visas that they piloted in early 2024. I know that a number of members of Congress had written to Secretary of State Marco Rubio a few months ago, urging him to reinstitute and make permanent that program that would alleviate burdens on the State Department and on foreign national employees and their employers. But alas, we are where we are right now with potential backlogs and huge volume of visa applications due to the interviews that need to be scheduled. Pivoting a little bit, Kim, I know late last week there was another new development in the courts related to TPS for Venezuela. This is such a complex and confusing situation. Can you clarify for us?
Yeah, so there seems to be lately some announcement or court decision on a Friday that impacts TPS. Our committee is kind of laughing about it. It seems like there's always something happening on Friday and throwing us into, okay, how do we digest this and get the information out to everyone? So the latest was this past Friday, in which Judge Chen of the U.S. District Court for the Central District of California granted summary judgment in favor of the plaintiffs, which is the National TPS Alliance, so the TPS holders essentially. He ruled that both the 2023 vacatur and the termination publications by Secretary Nome for Venezuela were unlawful. He also ruled that the partial vacatur for Haiti was unlawful as well. So previously, regarding Haiti, DHS had partially vacated Secretary Mayorkas's 18-month extension of that TPS designation. And instead of the designation expiring on February 3rd, 2026, it was going to expire now on August 3rd of 2025. That potential vacatur was argued in court, and it was found that it was unlawful for Department of Homeland Security to partially vacate, or in other words, shorten the TPS designation period. So at this time, Haiti's TPS designation and work authorization have been held to be valid until February 3rd of 2026. So that's Haiti. There was a lot of back and forth in the court, but where we are right now is that Haiti TPS and work authorization valid until February 3rd, 2026. And then for the 2023 TPS designation for Venezuela, that has been restored to its original expiration date of October 2026. And this is because both the vacatur and the termination actions have been ruled unlawful by the court. Now, for 2021 TPS Venezuela, DHS published a notice in the Federal Register on September 8th that the 2021 Venezuela TPS will terminate in 60 days, which will be November 7th. So for now, TPS designation and work authorization for 2021 TPS Venezuela will not expire on September 10th, but it will terminate based on this new Federal Register notice on November 7th. So, of course, there's still litigation ongoing, so there can still be more twists and turns with these TPS designations and work authorization. So, essentially, what does this mean for HR and global mobility? Well, it's important for I-9 compliance reasons to stay on top of these developments as much as possible. And we understand it's not easy to do so. Even us attorneys are having little hesitation and lots of research to understand and break this down. So we don't expect employers to know the ins and outs of this. So as much as possible, reach out to attorneys, stay informed about what's going on, and then plan accordingly with re-verification of employment authorization, meaning make sure that you reach out to individuals when their work authorization is set to expire to determine if they have alternative work authorization, and also check and see if maybe there's been a twist in the courts and their work authorization has in fact been extended. But also, remember to plan for potential disruptions in business operations with the ending of a lot of these TPS programs. There is another update from the State Department. So we're going to go back to the State Department, and they have announced that all available EB1 and EB2 immigrant visas for fiscal year 2025 have been used up. So, Miki, what can you tell us about this and what does it mean?
Yeah, so as global mobility and HR professionals know, there's a fixed number of green cards available per government fiscal year. And each month, the State Department publishes a monthly publication called the Visa Bulletin to announce the cutoff dates for green card availability for that month. And there's separate cutoffs for each employment based preference category from first preference through fifth preference. And the State Department has now announced that it has reached the annual limit of available visa numbers for both EB1 and EB2 categories for this fiscal year. And the EB1 category generally includes individuals of extraordinary ability, outstanding professors and researchers, and certain multinational executives and managers. The EB2 category covers positions that require an advanced degree, master's or higher, or the equivalent, which is bachelor's degree plus 5 years of progressive experience. This includes both perm-based green card cases and those exempt from labor market testing, such as national interest waivers and Schedule A occupations. So with the numbers now used up for both EB1 and EB2, U.S. embassies and consulates may not issue immigrant visas or green cards in these categories for the remainder of the fiscal year unless the consular officer had already reserved that visa number. So for employees who already had visa interview dates scheduled, Global Mobility and HR should check with their immigration counsel.
So those are a lot of changes that are happening with the State Department and visas. So thanks, Miki, for all those updates. What about for those applicants who are adjusting status from within the US, meaning processing their green card applications while in the United States on a work based non immigrant visa? What's going on with those cases?
Yeah. So for USCIS, as with its practice in prior years, should be continuing to accept I-45 applications for filing if the foreign national's priority date is before the cutoff date published in the visa bulletin for September. However, no more I-485 applications will be approved in September. The good news, though, is that October 1st is right around the corner. It's the start of the fiscal year, and there will be a fresh supply of green card numbers at that time.
Yeah, it's hard to believe that October is only a couple of weeks away, essentially. Our director of visa consulting, Charlie Oppenheim, is featured in our monthly webinar with Sharina Garcia on Chatting with Charlie. So you can register to join their discussion on what's happening with the visa bulletin, and that will be on September 25th. So we encourage you to jump in that and register and see what's going on. So, with that, I guess it's a wrap on this week's Rapid Fire Wednesday. We'll continue monitoring legislative, regulatory, and court developments, as well as agency guidance, and provide updates in future episodes as we hear of them. So, as always, for the latest updates to the immigration landscape, please follow WR Immigration on LinkedIn, as well as Miki and my personal profiles for breaking updates and insights. And we also transcribe each and every episode of Rapid Fire Wednesday and share it through our weekly newsletter, which you can subscribe to. The link to subscribe can be found in the video description. Thanks for joining us, and we'll see you next time. Great seeing you, Miki, and see you in Boston in a few days.
See you soon.